Okay, good morning. Please be seated. Computer's going. This is case number 2018 CA 5321. Jack Kowalski, etc. et al. Versus Johns Hopkins All Children's Hospital. Starting with the plaintiffs. Let's take appearances, please.
Greg Anderson, Nick Whitney, and Samantha Lawrence on behalf of the plaintiffs.
Howard Hunter, Ethan Shapiro, Pat Crowells, David Hughes, and Chris Altenburn on behalf of Johns Hopkins All Children's Hospital. And our corporate representative today is Dr. Richard Elliott.
I see Mr. Altenburn's here in the courtroom. I did receive the further edits to the instruction. I know I think there were 3 changes. On page 2, I'm still not enamored with the proposed sentence disagreements concerning her treatment could be addressed by the dependency court. So my thought is we just don't say that right this second, and we'll continue to have discussions for the final version.
So when do you plan to read the final version?
Well, my understanding is that you all wanted me to read this today, and then we were going to have a written version that would go to the jurors with the collection of jury instructions.
Okay, especially in the written one, I'm concerned with it ending in to participate in decisions concerning their treatment, because I think it needs more.
And I think we need to come up with some language that I can live with, you can live with, and the plaintiffs can live with. And I just don't think we're there on that one sentence yet.
Okay. And I had suggested a minor change to a sentence on page.
On page 4.
4 it is. I'm sorry, the blue highlighting, at least when it prints out, is darker than
My view on that, instead of using the word direct, let's use provide. So it would say the dependency court did not provide that Johns Hopkins could supervise the calls.
Okay.
Okay, I think we're threading the needle the best with that word.
Okay.
Your Honor, last night, for the first time, I had an opportunity to review the proposed order, and I took a stab at revising our version of it. You should have it right around now. I know you're invested in this one. I did not get a chance because, I'm falling asleep with the computer on my chest trying to get ready for the next days, but I finally got 99% of it done. You should have it, all counsel should have it within the next 5 minutes. And I would really like to take a stab at helping, because I read through this, and just from trial counsel's point of view, I think it is going to raise so many questions with the jurors at this point that it's going to add days to this trial. And I honestly believe that. I want this to be as efficient as I can. I want both sides to have a fair shake at how to handle these orders. But I think there's a way to cut out a tremendous part of this. And my theory is this, that now that we have the history to compare to the orders, there's a bunch of terms, conditions, and in fact orders, such as the birthday order, which really have no bearing. There's no continuous time frame or alteration of time frame that would affect the jury's deliberations. So what I tried to do was, and I know nobody's seen it, and I apologize, I just ran out of sleep time, I don't know. But my thought is, if we can trim it down to the essence of those points that describe what they need to know as opposed to all of the orders, I think it would be more beneficial. And so that's what mine attempted to do. And again, I wish I could have gotten to it sooner, but I just got to prepare for trial too. So, we could, perhaps over lunch, the court would have an opportunity to go through our proposed order. It's not brand new, it dovetails off of.
Well, let me ask you this,
Mr.
are you
Ellis's.
just cutting things out, or are you altering language?
Both. But I think, at least opposing counsel has seen the version that, I was working off the one that you, Mr. Altenberg and Mr. Elliott were working on. So I think there is, again, quite a bit of it that is the same. In terms of the direct, when the court did the direct quotes of the orders, that's left in. It is simply cutting out some.
I'm not even sure he's looking at the
The old order, I
most
just
recent
responded.
versions at this point. Honestly, because we don't have direct quotes in the version
Yes,
where
it
we're
is.
at.
Yes.
Yeah, I don't think he's
My-
dealing
my-
with.
My position is that we've wanted to give this to the jury sooner, and admittedly, it's complicated, it's taking time, but the longer we wait, the more confused the jury remains on
Well,
I completely disagree. I think that this is
time out.
something
Let's do this. You say you have sent it or are sending it momentarily?
momentarily, Ms. Stump is she sending right
She
now?
sent it, yes.
All right, you should have it, the court should have it, counsel should all have it. I have a printed copy. of it.
Mr. Altenberg, were you going to be here today, or were you just coming this morning
I
for
was
this issue?
planning to make a cameo and go back and work on jury instructions, but I can stay a little while longer at least. But, I will tell you on the jury instructions, I think we should have a packet to you, hopefully by, I'm not sure how soon you want it, but by sometime early this afternoon. The biggest concerns in that packet, at least from my perspective, are on the count 14 stuff. We're getting close to when we're supposed to rest, and I still don't know what the issues are, whether it's going to be a standalone negligence claim or whether it's going to be fitted in to med mal. Right now, what they're sending me is a standalone simple negligence claim that our training caused damages without any reference to a doctor being negligent in the interim. So there's problems with that one that I really need to understand before we can rest.
And do we have a verdict form draft coming
We're,
with it?
we're in the midst of that, but I think we can make great progress on that today.
I mean, I would like, and I know you and Mr. Elliott are working hard on making it happen. I don't want to give you a deadline,
Right.
but
I mean, I think we can
I'm
give
in
you
the
something
point-
that's a working document by tomorrow. I do. But some of it depends a little bit on some of the jury instructions. But I understand the format he wants, and I think we can probably work together on that today quite a bit. I understand that he has a law school reunion this weekend in Boston, and he's not going to be available for much this weekend, I guess. So.
well, the sooner that you can get it to me, the better. I get that's the best. I don't want to put a time limit on it because I don't want
Right.
to impact what you and Mr.
And
Elliott.
could I suggest that it'd be faster and easier if I can get you kind of the questions they're going to answer yes and no, and the elements on damages without worrying too much about the formatting of it, because the formatting of a verdict form is gobbles time for me.
I'm probably going to end up doing the formatting
Well,
myself.
and that's actually what I told Mr. Elliott.
So I'm not worried about your formatting so long as
Okay.
it is in logical. We'll
Again,
clean it up.
I think by tomorrow morning we can give you the logics of this and the language pretty close to what you need to work with. So, and I will make that as my goal.
I can.
If I stay late this evening trying to do it. So.
Ms. Syback just brought in, I guess, Mr. Anderson, so I can hand you this, and
Yes, 'cause I
Ms.
don't-
Syback can print me another copy and bring that in. If you want to make a cameo again right after lunch
On this and the other things,
on that issue,
I'm happy to do so.
and that way I don't hold you here, but
And I can give you progress on what we're doing on the other things by that point.
Bob Ray.
But on let's close the loop on this. I really want this issue to be put to bed coming out of lunch. So,
Should I get with counsel first and then talk to the court?
well, he's got your work product, so can he take your work product and then, if necessary, talk to Mr. Elliott this morning?
Absolutely, absolutely, that was the intent.
But, I don't know,
May I ask, this isn't a red line, this is just a set of changes?
There's a red line version emailed
Okay.
to you.
Okay.
Well, I'm absolutely confident both Mr. Altenberg and Mr. Elliott are horrified at the thought of trial counsel getting in on their instructions. Anyway,
well,
I would attempt.
I'm told the copy that was served is not red line, I'm not sure I can tell on
It's
my
not,
phone.
the one email that we're looking at has no red lines on.
did you get a red line version?
I'll make sure we get the red line version over.
Okay. If we get a red line version, she can print it and we can give it to you, Mr. Altenberg, and then
Well,
you can
if-
take
if
off,
she-
or?
if they serve it to me by the time I get back to my
Great.
alternate office, I can print it out there.
Altenburn Office South?
Yes, and you want me back here at 1 o'clock, right? I'm happy to do that.
I don't know what time we're gonna take lunch today, because I don't have
At the end of
a,
lunch is when you want it.
correct, so hopefully around one-ish.
All right, thanks a lot.
And I want to check where the defense is on Fabre. They've been stating that they were making a decision, that they made a decision on.
We have not.
But I should have a decision by lunchtime.
Okay.
What's next?
Judge, I have exhibit I need to put in before the witness this afternoon. It's a new exhibit it's not a new exhibit. It's an exhibit that the plaintiff has put in, but I've divided it into two packets because the defense position is that there are morning photos and there are afternoon photos. And so they merged them all together and mixed them up. So I divided them up. So I would like to admit 3401.
Is this on this list?
It should be on the list. It is on the list. It's the last exhibit. I'm sorry, to put it in order, there's 3400. And I've given a hard copy of this to the plaintiff's counsel, 1 through 14,
We object, but I'll wait.
and 3401, 1 through 9.
Okay, and so,
Okay.
just tell me what these are before we look at
Sure.
it.
Here's the deal, Judge. They put all these photos, they're already in evidence, all of these photos. They mixed them all together. You can tell by looking at them, in some of the photos she's in blue shorts, and some of the other photos she's in pink shorts. They merged them all together, they're all mixed up.
Is this the before and after court?
Correct, Your Honor. So I divided them up by before and after court, and I want to use them in that fashion with the witness, because otherwise it's totally confusing for me to be able to use the exhibit. It's the same exhibit, simply divided into morning and afternoon.
So all of these exhibits are already in,
That's correct, Your Honor.
and it's just a
Yeah.
reorganization and putting them, so what's the issue, Mr. Whitney?
Your Honor, first of all, they're already in. They can make the argument about blue shorts or pink shorts without putting this photographs into evidence twice. Secondly, what they've labeled as 3400, you'll notice, is not bait stamped. 3401 is. So the accusation that we mix these all up, we don't know the progeny of 3400 since there's no bait stamp on this.
Well, how about 3400-2? Are there any base
There's
stamps?
no bait stamp on, I just looked at all of them. Anywhere in 3400 there are no bait stamps.
Judge,
And we must say, Judge, that our information.
Can we go back to just one
Yeah.
lawyer per subject?
Yes, sir.
Thank you.
Judge, I don't recall if their exhibit has bait stamps on them, but we can put the bait stamp on there if that's the issue.
Were the ones that came into evidence already, did they have bait stamps?
I don't recall, Your Honor, and I don't know if they just had exhibit numbers, if they had bait stamps. Perhaps counsel can
They
enlighten
did,
us.
Your Honor. Ours had bait stamps, and
Can you give me just tell me the exhibit number that's in evidence and pull it up real quick?
it looks like 2604-006, 2604-001.
Let's just pull up the first one.
2604-006, 2604-001.
Yeah, those are on.
And you'll see, these have bait stamps.
Well, Judge, we can put the bait stamp back on if that's truly an issue. I mean, there's no question they're the same photos.
And all I'm seeing here are 3 photographs. I don't know if, I'm sorry? Oh, they're not here in front of me, okay. They all have bait stamps. We introduced them in the way they were produced to us, so the mixing up of order is not the blame doesn't go to us for that. This is the way the hospital produces them with bait stamps. We put them all in evidence. They can make their argument about blue shorts or pink shorts. There's a factual dispute about whether there were before and after photos. Of course, they take the position there were. Maya Kowalski says it happened one time. Kathy Beatty forced her in a dress in front of her and changed her before court. That's a factual issue that they can take up with the photos that are already in evidence.
We'll be happy to put the bait stamp numbers on. I think probably got deleted when we put the new exhibit number on. Happy to put the same bait number now so they can do a comparative analysis. They're clearly the same photos. It would be, I do not want, I think the defense has the right to have the jury see these as 2 separate packets, one before and one after, as opposed to getting them all mixed up when they're back there in the jury room.
The other point I need to
clearly,
make.
I'm sorry.
Oh,
Go ahead, Ms. Quarles, you can finish.
Sorry.
These are clearly, in our view, and the testimony will be, 2 separate photo sessions.
The other point I need to make is there's no date and timestamp to confirm that. So what's the point of putting them in this fashion? They're already in evidence. They can make their argument. If they were time-stamped and dated differently, if one was a morning set and one was an afternoon set, from the face of them, perhaps. But that's not the case.
I think at this point, Ms. Quarles, if these photos are already in, let's just go with what's already in. I don't want to, if Mr. Whitney is correct that these were produced in a different fashion and not as a coherent set, I don't want to be seen as glossing a coherent set. If they're already in evidence, let's just go with them as in evidence.
Okay.
Next issue.
Just as a matter of scheduling, the court had told the plaintiffs yesterday when we tried to publish emails, whether we could just publish them or need to publish them through the witness since we're running out of trial days. The court asked the plaintiff to make a commitment this morning. So we would like to hear from the plaintiff whether they would require us to call a witness to publish or if we could just start publishing.
Anything further on?
I'm sorry, I wasn't paying attention. We were not allowed to do so, Judge. We had to put ours in context with a witness, was the court's ruling. We do not believe that it's appropriate nor particularly time efficient to stop the testimony to simply have the jury stare at the screen for a minute on each one of these. So we would object to just simply having them put in without a witness, any context or anything else.
Did I allow the plaintiffs to publish without a witness? And I'm not talking about a situation where we had a deposition and then published exhibits that occurred in the deposition, but did I allow plaintiffs to do this?
I did not. During the course of what I was doing, unless Mr. Whitney remembers differently, during the course of what I was doing, we did not have that, and we actually asked for it within the first week to be able to put some of the documents into evidence before we had a witness up. We were not allowed to do that. The court wanted it to be in context with a witness if we're going to bring them in, and it's a waste of time here to just have the jury stare at these. I mean, at least have some context.
The court did allow them to publish, for example, policies and procedures at the hospital without calling a witness. In terms of efficiency,
Was that in relationship to a deposition, or did I just?
I believe my sincere recollection is you just let them publish. In terms of efficiency, it's going to be far more efficient of the court's time for us to just publish, let them read, than for me to call a witness and walk them through. But if they're going to require me to recall an expert, require me to call somebody like Dr. Rich Elliott as a team mate?
Here's my thought.
Yeah.
I don't want to just force people to spend money to publish a document that's in evidence. I think at the bottom line that is wasteful of everyone's time, money, and energy. But I don't want to spend time publishing 30 emails. So, if you can do a handful and then perhaps get some others through a witness.
Yeah.
Obviously, I will keep your time running during any publishing that you do, but I will allow you to do a couple of them without a witness.
Okay, so we will likely publish maybe 3 today. Okay, thank you.
What's next?
Judge, I guess now, unless the defendants have found something overnight, we still do not have the 2017 review of Kathy Beatty, which would be the one that encompasses the actions of the fall of 2016. And we need to know, once and for all on the record, whether that exists or not. And if it doesn't exist, then we may need to recall the defendant's expert on that point, because his opinions, the court may recall, included a review that apparently does not exist. So have they found it?
I believe we did inform counsel last night, but I double-checked with my client's HR department, and the last review for that period ran through October 27th, 2016, which is the one that they were handed. Because they changed over systems, the next review did not start until July 1st, 2017, after the incident in question, 2018. Yeah, there's no written review after 10/27, so there is none to provide for the second part. Yes.
So there's no review of employees by the hospital? I mean, that's what I'm hearing you say.
There's no written review of this employee between 10/27/16 and 7/1/17 when the next.
Are there written reviews of other employees?
I'd have to double check that, Your Honor.
Can I add, Judge, my understanding, in speaking with the hospital, that they had a changeover in system. And because of that, there were no reviews done in October of 2017. They were done in October. In October of 2017, there isn't one. It's not until later that there's one. But I think the point, Judge, is the witness was testifying based on a document that ended in October of 2016. To the extent that the jury or the court or the other counsel is concerned that they were given the impression that there was a review he reviewed after that, we're willing to stipulate to a statement being read to the jury that says the review that was testified to by Mr.
Anderson.
Thank you. That's right, Anderson. Mr. Anderson was a review that ended in October of 2016. He did not review anything post-October 2016.
Well, it seems hard to believe that an organization did not conduct reviews. How did the hospital make decisions on whether to give an employee a raise or not a raise? I mean, it would seem to me that an organization would not go more than a year without giving employees raises based on some sort of review. And I know of no organization that is of a large, that doesn't keep written documents of performance. Maybe small companies where the owner knows everybody, but
I hear you, Judge. The